Our chief guest today shares deep ties with the state of Bihar, which makes his presence here today all the more special. His many significant judgments that are well documented in the public arena are testimony to his keen insight, perception, and decisiveness in upholding our constitutional values under a pleasant demeanor and a kind smile while firmly presiding over his court. True to his promise he made to us last year, sir, we are deeply honored to have you amidst us today, and I welcome you to please deliver the keynote address for the second Justice Ajay Kumar Tripathi Memorial Lecture.
Shri Vinod Chandran, the Honorable Chief Justice of the Patna High Court, my all esteemed brothers from Patna High Court, my senior colleague Justice Mukhopadhyay and Justice Hemant Gupta who are present here, Shri Y.V. Giri, the learned senior counsel, Shri Devesh Thakur, the chairman of the Bihar Vidhan Parishad, Shri Nikhil Kumarji, the former governor of Kerala and Nagaland, Shri Anand Badar, the chairman of the Human Rights Commission, State of Bihar, Shri P.K. Sai, the learned Advocate General, Dr. Ravi Ranjan, the former Chief Justice of JAKT High Court, Shri Manan Kumar Mishra, the chairman of the Bar Council of India, Shri Ramakant Sharma, the chairman of the Bihar Bar Council, Srimati Alka Tripathi, and the other family members of Justice Ajay Kumar Tripathi, the learned senior members of the bar present here, the members of the bar, the respected dignitaries who have come in large number to commemorate the memory of Shri Justice Ajay Kumar Tripathi, and friends. It gives me an immense pleasure to be with you all on the occasion of second Justice Ajay Kumar Tripathi Memorial Series. All the learned preceding speakers have spoken about Justice Ajay Kumar Tripathi. We are all aware about his immense contribution to the legal system. I had an occasion to personally know him from a number of years. We met for the first time in 2008 when my father was the governor of Bihar and he was a judge. We had come here for the oath ceremony of Justice Loda, who was also our colleague in the Bombay High Court. And I met him for the first time there. And thereafter our friendship grew. We used to meet on a number of occasions. We used to socialize. And therefore, we came to Delhi almost at the same time. He came as a Lokpal and I came to Supreme Court after 2 months or so after his coming to the office of Lokpal. And therefore, it was a rude shock to me when in the early Corona days, I think he was one of the first casualties from the legal faculty. And last year when I came to know about the event organized to commemorate his memory, I again came in contact with his family and I had assured them the last year itself that next year when you will hold the function, and that too in Patna, it will be my pleasure to be associated with it. I deem it a great honor to be associated with a function to commemorate a memory of such a fine legal mind, such a fine judge who has contributed immensely to the development of law. Justice Tripathi, as has been told to us by earlier speakers, was a devoted family man. He was a perfect son. He was a rock support to his wife and children, encouraging and taking pride in their achievements. I'm really happy that this family has taken this plunge to form a foundation and take pride in his achievements, and as a family to use the tools he gave them to continue to do his work and remember him. I pay my deepest homage to the memory of Justice Ajay Tripathi. With this, I will come to the topic for which I have been invited to speak today evening. Our Constitution and the idea of India therein. For considering today's topic, we'll have to go into the history of making of the Indian Constitution. Preparing a constitution for a country like India was not an easy task. As all of us know, India is a country full of diversities. On a geographical plane, we have genetical Himalayas on one hand and a vast seashore on the other side. We have people belonging to different religions, different beliefs. We have the Malays of caste systems. Prior to preparation of our constitution, India witnessed not only the struggle for the freedom of India, but also a fight by the downtrodden for their upliftment. We also had tribals residing in remote areas who were kept away from the mainstream on account of geographical reasons. The Constituent Assembly consisted of many scholars and people from the different fields. It consisted of members belonging to different castes, region, as well as the representative of the provinces. It consisted of people belonging to different philosophies like capitalism, socialism, communism, etc. As the learned Chief Justice has referred to, two of the eminent members of the Constituent Assembly were from the state of Bihar. The first chairman of the Constituent Assembly, Dr. Rajendra Prasad, who also became our first president, and Sachidanand Sinha. Their contribution in the framing of the Constitution can never be forgotten by anyone. The proceedings of the Constituent Assembly began with the objectives resolution, which was moved by Pandit Jawaharlal Nehru on 13th of December 1946. Among the other things, the objective resolution provided that the Constituent Assembly would resolve to proclaim India as an independent sovereign republic. As per the objective resolution, India was to be a union of the territories that form the Indian states and other parts of India which are outside British India, and then constitute into an independent sovereign India. As per the objective resolutions, the states were to be the autonomous units having all the residuary powers and exercise all functions of the government except such as the powers which are to be vested in the Union. As the learned Chief Justice said that the power and authority of the sovereign independent India was to be derived from the people of the India. There is also a commitment to the justice, social and economic and political, the freedom of thought, expression, belief, faith, worship, vocation, association. Then the objective resolution also aimed at providing safeguards for the minorities, backward and tribal areas, and depressed and other backward classes. It also resolved its commitment to the promotion of world peace and the welfare of the mankind. As all of us know that Dr. Ambedkar is now considered as the father of the Indian Constitution and the main architect of the Indian Constitution. He always believed in the paramount interest of the country. I'll quote from one of his earliest speeches in the Round Table Conference on 20th of November 1930. I quote him, "We must have a government in which the men in power will give their undivided allegiance to the best interests of the country. We must have a government in which men in power, knowing where obedience will end and where resistance will begin, will not be afraid to amend social and economic code of life, which the dictates of justice and expediency so urgently called for." Unquote. Immediately after the objectives resolution was moved by Pandit Jawaharlal Nehru, Dr. Ambedkar was called upon after 4 days to address the Constituent Assembly. He expressed his displeasure with lack of certain provisions in the objective resolution. I quote from his speech of 17th of December 1946. He said that, I quote, "I should have expected some provision whereby it would have been possible for the state to make economic, social and political justice a reality." Dr. Ambedkar was of the view that the rights without the remedies were meaningless. The vision of Dr. Ambedkar could be seen in his first speech, could be seen from the provisions that are found in the Indian Constitution under Article 32 and 226, which are provided solace to the millions of citizens of the country. In the same speech, in the speech of 9th of December 1948, describing Article 32, Dr. Ambedkar quotes, "If I was asked to name any particular article in the Constitution as the most important, an article without which the Constitution would be a nullity, I could not refer to any other article except this one. It is the very soul of the Constitution and the very heart of it, and I am glad that the House has realized its importance." Dr. Ambedkar's zest for patriotism and nationalism could be seen in the following words when he spoke on 17th of December 1946, and I quote, "When deciding the destinies of nation, dignities of people, dignities of leaders, and dignities of parties ought to count for nothing. The destiny of the country ought to count for everything." Unquote. Finally, the objectives resolution came to be passed by the Constituent Assembly on 22nd of January 1947. Thereafter, Dr. Ambedkar, along with the others who were elected on the drafting committee of the Constitution. Subsequently, on 29th of August 1947, Dr. Ambedkar was elected as the chairman of the drafting committee. And as Dr. Rajendra Prasad has said in his speech on 26th of November 1949, that the most wisest decision that the Constituent Assembly took was to make Dr. Ambedkar a chairman of the Constituent Assembly. After putting Herculean labor, the drafting committee prepared the first draft of the Constitution. The said draft was introduced to the Constituent Assembly by Dr. Ambedkar when it met on Thursday, the 4th of November 1948. It's a matter of great coincidence that today, exactly after 75 years, we are meeting today from the date on which the final draft was presented by Dr. Ambedkar to the Constituent Assembly. I don't think that there would have been any more tribute to Justice Ajay Tripathi than celebrating the 75th anniversary of presenting of the final draft. It's a matter of great coincidence because Srimati Tripathi wanted it to be on the next weekend, but then we realized that 12th would be a Chat ceremony and it would be impossible to move in Patna, on the streets of Patna, and therefore it was preponed by a week. But I think destiny desired that Justice Tripathi's memorial lecture should be on the day on which the final draft of the Constituent Assembly was presented to the Constituent Assembly. It will be very relevant to refer to some of the observations made by Dr. Ambedkar while presenting the said draft. While speaking on 4th of November 1948, he introduced to the members of the Constituent Assembly the concept of dual polity. I quote, The draft constitution is federal constitution in as much as it establishes what may be called a dual polity. This dual polity under the proposed constitution will consist of the union and at the center and the states at the periphery, each endowed with sovereign powers to be exercised in the field assigned to them respectively by the Constitution. He emphasized on the workability of the Constitution, and I quote, all federal systems, including the American, are placed in a tight mold of federalism. No matter what the circumstances, it cannot change its form and shape. It can never be unitary. On the other hand, the draft constitution can be both unitary as well as federal according to the requirements of time and circumstances. In normal times, it is framed to work as a federal system. But in times of war, it is so designed as to make it work as though it was a unitary system. Once the President issues a proclamation, which is authorized to do under the provisions of draft Article 225, the whole scene can become transformed and the state becomes a unitary state. The union under the proclamation can claim, if it wants, one, the power to legislate upon any subject, even though it may be in the state list, the power to give directions to the states as to how they should exercise their executive authority in the matters within their charge. 3, the power to vest authority for any purpose in any officer. And 4, the power to suspend the financial provisions of the Constitution. Such a power of converting itself into a unitary state, no federation possesses. This is one of the points of difference between the federation proposed in the draft Constitution and all other federations we know of. Dr. Ambedkar stated that the Indian Federation will not suffer from the faults of rigidity or legalism, as its distinguishing feature is that it is a flexible federation. In that regard, he highlighted certain provisions of the draft Constitution, and I quote him, first is the power given to Parliament to legislate on exclusively provincial subjects in normal times. I refer to draft Article 226, 227 and 229. Under draft Article 226, the Parliament can legislate when a subject becomes a matter of national concern as distinguished from purely provincial concern. Though the subject is in the state list, provided a resolution is passed by the upper chamber by 2/3 majority in favor of such exercise of the power by the centre. Draft Article 227 gives a similar power to Parliament in a national emergency. Under draft Article 229, Parliament can exercise the same power if provincials consent to such an exercise. The second means adopted to avoid rigidity and legalism is the provision for facility with which the Constitution could be amended. The provisions of the Constitution relating to the amendment of the Constitution divide the articles of the Constitution into 2 groups. In the one group are placed articles relating to the distribution of legislative powers between the center and the states, and in the second group, the representations of the states in Parliament, and third, the powers of the court. He said that all other articles are placed in another group. Articles placed in the second group cover a very large part of the Constitution and can be amended by Parliament by a double majority, namely a majority of not less than 2/3 of the members of each house present and voting, and by a majority of the total membership of each house. The amendment of these articles does not require ratification by the states. It is only in those articles which are placed in Group 1 that an additional safeguard of ratification by the states is introduced. And therefore, we find that though the Constitution is flexible insofar as general amending powers are concerned, insofar as the important aspect with regard to distribution of legislative powers, the representation of states in parliament, and the powers are concerned, there is a rigidity and the amendment cannot be carried out easily unless there is a ratification by half of the state legislatures. Dr. Ambedkar also highlighted the fact that the draft constitution had sought to forge means and methods whereby India will have a federation and at the same time will have uniformity in all the basic matters which are essential to maintain the unity of the country. We can therefore see that those of the entries, subjects which are important for the nation, for the security of the nation, for keeping the nation united, like the defense, the foreign affairs, the communications, etc. find place in the union list, whereas the subjects which are more nearer the interests of the people residing in the state, like trade, agriculture, police, law and order, are kept in the second list, whereas there are many subjects like forests, education, marriages, etc. kept in the concurrent list. To keep the country united, our constitution also provides for single citizenships and two ways of federal structure. Unlike the American Federation, we have a single citizenship. A citizen residing in any part of the country, either in the northeast or west or south, he is a citizen of India and not a citizen of a particular state. Whereas in American Federation, a person has dual citizenship. He or she is a citizen of the United States of America as well as the state to which he/she belongs. It will be apt to quote from his final speech on 25th of November 1949, which states, "The proposed Indian Constitution is a dual polity within a single citizenship. There is only one citizenship for the whole of the India. It is an Indian citizenship. There is no state citizenship. Every Indian has the same rights of citizenship, no matter in what state he resides." Our constitution further provides for a single constitution to keep the country united. Unlike US Federation, wherein the center as well as the states have different constitutions, our constitution provides for only one Indian constitution. To quote Dr. Ambedkar, "This is not true of the proposed Indian constitution. No states have a right to frame its own constitution. The constitution of the union and of the states is a single frame from which neither can get out and within which they must work." Furthermore, Dr. Ambedkar stated that the three means adopted by the draft constitution to maintain the unity of the country are: one, a single judiciary; two, uniformity in fundamental laws, civil, criminal; and third, a common all India civil service to man important posts. In respect of unified judiciary, he said, and I quote, "The Indian Federation, through a dual system, dual polity, has no dual judiciary at all. The High Court and the Supreme Court form one single integrated judiciary having jurisdiction and providing remedies in all cases arising under the constitutional law, the civil law, or the criminal law. This is done to eliminate all diversity in remedial procedures. In respect of uniformity in fundamental laws, civil and criminal, Dr. Ambedkar said, and I quote, "Care is taken to eliminate all diversity from laws which are at the basic of civil and corporate life. The great codes of civil and criminal laws, such as the Civil Procedure Code, the Penal Code, the Criminal Procedure Code, the Evidence Act, Transfer of Property Act, Law of Marriage, Divorce, and Inheritance, are either placed in the concurrent list so that the necessary uniformity can always be preserved without impairing the federal structure. In respect of a common all India civil services, Dr. Ambedkar states, and I quote, "The dual polity which is inherent in a federal system, as I said, is followed in all federations by a dual service. In all federations, there is a federal service and a state civil service. The Indian Federation, through a dual polity, will have a dual service, but with one exception. It is recognized that in every country, there are certain posts in its administrative setup which might be called strategic from the point of view of maintaining the standard of administration. It may not be easy to spot such posts in a large and complicated machinery of administration. But there can be no doubt that the standard of administration depends upon the caliber of the civil servants who are appointed to these strategic posts. Fortunately for us, we have inherited from the past system of administration, which is common to the whole of the country, and we know what are these strategic posts. The Constitution provides that without depriving the states of their right to form their own civil services, there shall be an all-India service recruited on an all-India basis with common qualifications, with common uniform scale of pay, and the members of which alone could be appointed to these strategic posts throughout the Union. And therefore, we have seen that we have IAS officers, a person originally belonging to Northeast would be a collector somewhere in Bihar. A person from Kashmir would be a district superintendent of police in some other state. And insofar as Bihar is concerned, Bihar has always been a leader in the Union civil services. Most of the persons from Bihar are dominating the services that would be that IAS, IPS or IFS. And therefore, we find that one of these important steps has gone a long way in keeping the country united. The second reading commenced on 15th of November 1948. In the second reading, the Constitution was discussed clause by clause in detail. The discussions concluded on the 17th of October 1949. And thereafter, the Constitutional Assembly again sat on 14th of November 1949 for the third reading. In the last session of the Constitutional Assembly, all the articles were duly deliberated. There were various amendments proposed, some accepted, some rejected. And after that, Dr. Ambedkar presented the final draft on 25th of November 1949. His speech, that of 4th of November 1948, as well as the 25th of November 1949, give a great inspiration to the students of law, and I will appeal to the students of law to please read both these speeches. As a student of law, it will be really enlightening for everyone. He states in his speech, and I quote, "However a good constitution may be, it is sure to turn out bad because those who are called to work it happen to be a bad lot. However bad a constitution may be, it may turn out to be a good if those who are called to work it happen to be a good lot. The working of a constitution does not depend wholly upon the nature of the constitution. The constitution can provide only the organs of state, such as legislature, the executive and the judiciary. The factors on which the working of those organs of the state depend are the people and the political parties they will set up as their instruments to carry out their wishes and their politics." Dr. Ambedkar was of the view that we must make our political democracy a social democracy as well. To what would mean a social democracy, he secondly describes, and I quote him. He said that social democracy is a means, a way of life which recognizes liberty, equality, and fraternity as the principles of life. These principles of liberty, equality, and fraternity are not to be treated as separate items in the Trinity. They form a union of Trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality. Equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over the many. It will lead to a situation of laissez-faire. Equality without liberty would kill individual initiative. Without fraternity, liberty and equality could not become a natural course of things. It would require a constable to enforce them. Dr. Ambedkar highlighted that there are a complete absence of two things in the Indian society. The first one, equality, and the second one, fraternity. In relation to equality, he states, and I quote, "In politics, we will be recognizing the principle of one man, one vote, and one value. However, in our social and economic life, we shall be, by reason of our social and economic structure, continue to deny the principle of one man, one value." He stated that insofar as the social plane is concerned, India is divided into 4 compartments, and the compartments are such tight compartments wherein one cannot travel from one compartment to other compartment. On economic plane, he said that the wealth of our country is concentrated in few hands, whereas the millions of people find it difficult to even meet 2 ends in a day. And therefore, he warned that unless we take steps to eliminate these discriminations, the edifice of democracy we had so laboriously built up would fall like a house of cards. Dr. Ambedkar, with regard to fraternity, said that, and I quote, "I am of the opinion that in believing that we are a nation, we are cherishing a great delusion. How can people divided into several thousands of castes be a nation? The sooner we realize that we are not as yet a nation in the social and psychological sense of the word, the better for us. For then only we shall realize the necessity of becoming a nation and seriously think of ways and means of realizing that goal." To traverse the journey taken by the Indian Constitution, it will be also apt to rely on some of the judgments of the Apex Court which have taken these principles further. In the state of Rajasthan versus Union of India, the then Chief Justice M.H. Beg observed thus, and I quote, "A conceptus of the provisions of our Constitution will indicate that whatever appearance of a federal structure our Constitution may have, its operations are certainly judged both by the contents of power, which a number of the provisions carry with them, and the use that has been made of them, more unitary than federal." He further quotes, "In a sense, therefore, the Indian Union is federal, but the extent of federalism in it is largely watered down by the needs of progress and development of a country, which has to be nationally integrated, politically and economically coordinated, and socially, intellectually, and spiritually uplifted. In such a system, the states cannot stand in the way of legitimate and comprehensively planned development of the country in the manner directed by the central government." The learned Chief Justice proceeds to further observe, and I quote, "If then our Constitution creates a central government which is amphibian in the sense that it can move either on the federal or unitary plane, according to the needs of the situation and the circumstances of a case, the question which are driven back to consider is whether an assessment of the situation in which the union government should move either on the federal or unitary plane are matters for the union government itself or for this court to consider and determine. Each organ of the Republic is expected to know the limits of its own powers. The judiciary comes in generally only when any question of ultra-virus action is involved. Because questions relating to virus appear appertain to its domain. I already crossed my allotted 35 minutes, but I hope that you will be in a position to bear me for 10 more minutes. Like Justice Mukhopadhyay said, his speech was not at all boring, but my speech would be somewhat boring because it's a technical subject. I will now refer to the locus classicus on the principle of federalism, which is one of the most celebrated cases in the Indian jurisprudence. S.R. Bommai versus the Union of India, The Supreme Court Constitution Bench observes, and I quote, "The polyglot Indian society of wide geographical dimensions, habiting by social milieu, ethnic variety of cultural diversity, linguistic multiplicity, hierarchical caste structure among Hindus, religious pluralism, majority of rural population, and minority urban habitators. The social and cultural diversity of the people furnish a manuscript historical material for us and the founding fathers of the Constitution to lay federal structure as a foundation to integrate India as a united Bharat. Federalism implies mutuality and common purpose for the opposite process of change, with continuity between the center and the states, which are the structural units operating on balancing wheel of concurrence and promises to resolve problems and promote social, economic, and cultural advancement of its people, and to create a fraternity amongst the people. It further observes, and I quote, "The federal state is a political convenience intended to reconcile national unity and integrity and power with maintenance of states' right. The end aim of the essential character of the Indian federalism is to place the nation as a whole under the control of national government, while the states are allowed to exercise their sovereign power within their legislative and co-extensive executive and administrative sphere. The common interest is shared by the center and the local interests are controlled by the states. The distribution of the legislative and executive power within limits and coordinate authority of different organs are delineated in the organic law of the land, namely the Constitution itself. The essence of federalism, therefore, is distribution of the power of the state among its coordinate bodies. Each is organized and controlled by the Constitution. The division of power between the Union and the states is made in such a way that whatever has been the power distributed, legislative and executive, be exercised by the respective units, making each a sovereign in its sphere, and the rule of law requires that there should be a responsible government. Thus, the state is a federal status. The state, cause the center, has quasi-federal unit. In one of the recent judgments, in the case of State of NCT versus the Union of India, the court, the Constitution Bench, speaking through the Chief Justice, observed thus: "The principle of democracy and federalism are essential features of our Constitution and form a part of the basic structure. Federalism in a multicultural, multi-religious, multi-ethnic, and multilinguistic country like India ensures the representation of diverse interests. It is a means to reconcile the desire of commonality along with the desire for autonomy and accommodate diverse needs in a pluralistic society. Recognizing regional aspirations strengthens the unity of the country and embodies the spirit of democracy. Thus, in any federal constitution, at a minimum, there is a dual polity. That is, two sets of government operate. One at the level of the national government and the second at the level of the regional federal units. This dual set of governments elected by we the people in two separate electoral processes is a dual manifestation of the public will. The priorities of these two sets of governments, which manifest in a federal system, are not just bound to be different, but are intended to be different. Justice Krishna Iyer labels the Indian Constitution as the nation's safety wall. And these four words embrace the entire essence and spirit of our Constitution. To quote Justice Krishna Iyer, "The Indian Constitution is a cornerstone of a liberated nation. It lays the grand foundation of a great people's political edifice of governance. It spells out the fundamental rights and socialistic aspirations of the vast masses long inhabited by the imperialistic ethos. It creates a trinity of democratic instrumentalities with checks and balances, parliamentary in structure, quasi-federal in character, an independent judiciary, an accountable parliament, at the center and like legislatures at the state level. A powerful election commission and fearless critical comptroller and auditor general provides a paramountcy of democracy. At once responsible and responsive, judicial review of state action, public finance auditable by a constitutional authority, obligation to seek fresh mandate through general elections with audit franchise, accountability, direct and indirect, to the people in several ways. These are fundamental in the governance of the country. The people, though free, have fundamental duties mandated by Article 51A of the Constitution, to exercise which, as in cases of environmental and ecological preservation, compassion for living creatures, protection of the value of composite culture, the authority of judicial writ power may be moved in it. On the 26th of November this year, we will be entering into our 75th year of the working of the Constitution. And if you look at the functioning of the Constitution for the last 75 years, its interpretation by the courts, we must realize that though the country has gone through many ups and downs, the framers of the Constitution have enabled our country through the Constitution of India, that is Bharat, that in times of external wars and internal disturbances, the country has always remained united and strong. When we compare our situation in our country with those of the neighboring countries, we will realize how lucky we are to live in India, that is Bharat. However, to make India, that is Bharat, as a country as inspired by our Constitution framers, we must make every attempt possible to eradicate the social and economic inequalities, so that India, that is Bharat, as envisioned by the framers of the constitutions, comes into reality. On this occasion, we must pledge ourselves to make every possible effort in that regard. I, on this occasion, once again express my gratefulness to Srimati Alka Tripathi, their loved daughters, Ms. Anushri Tripathi, Ms. Aditi Tripathi, Ms. Akriti Tripathi, and their son-in-law, Rahul Narayanan, who have organized this function to keep alive the memory of great soul of justice, Ajay Kumar Tripathi. They have also organized many events like the essay competition, etc., which will really help the students of the law colleges in a great way in enriching themselves. I extend my wholehearted congratulations and support to Srimati Tripathi and their family in their endeavor. I wish them all the best for the efforts they are taking in this direction. I am sure that their endeavors in organizing various events, including in the field of betterment of legal education, which provide human service to the society, will always keep memory of Justice Tripathi alive and inspire one and all. I once again pay my homage, deep homage, to the memory of Justice Ajay Tripathi. Thank you very much for bearing me for such a long time.